Today, our guest presenters will be Reverend Rickey Nelson Jones, Second Vice President, and Chairman Stephen Waddy, Political Action Chair. And they will be presenting to us information on the, as it relates to the advisory board and the new police reform bill that has been approved. So at this time, I would like to turn them, and this will go on a little bit longer than usual. And after the presentation, there will be the opportunity for asking questions. We want the membership to be aware that they're in the planning stage to develop this community advisory board. So at this point, I will turn it over to Mr. Waddy, Chairman Waddy, and Second Vice President, Reverend Rickey Nelson Jones.
Good morning, everyone. Mr. Waddy, if you don't mind, sir, I'm going to go ahead and start off by giving people some information about the shortcomings of the Law Enforcement Officers Bill of Rights, and then talk about the key aspects of the Maryland Police Accountability Bill. If you don't mind, I would like to go ahead and start off with that, and I'll let you pick up and start telling everybody about what the executive or the county executive has proposed. And then once you finish that, then I'll come back with some recommendations for us to consider. If that's okay with you, Mr. Waddy.
I'm sorry, I gave the thumbs up. That's great.
I say, okay. We all know about the Maryland Police Accountability Act of 2021. And so what we're going to do is we're going to talk about some key aspects of it. I'm going to share part and Mr. Waddy is going to share the other part. But before we go down that road, let me just kind of remind everybody of the Maryland, of the Law Enforcement Officers Bill of Rights, so we can understand how damaging that was and how this bill, this new bill, is very helpful here. The Maryland Enforcement Officers Bill of Rights has been described as, I want to use the exact words, it's been described as a blueprint for covering up police misconduct. The state of Maryland was the first one to pass this particular bill. And there's certain aspects of it that were just really damaging to the community. Number one, the complaint had to be signed and sworn to under the Law Enforcement Officers Bill of Rights. So even though somebody will complain about it verbally, they will call the police station, things of this nature. If they did not have a written, signed, sworn statement, it was not considered. It seems to me that once somebody has a complaint, all of these formalities do not erase the fact that you have a serious issue with the police department. So that was one of the major shortcomings of it. Another one was the hearing board would consist of law enforcement officers. We've heard said in the past, how can the police officer, so to speak, regulate themselves? And so that was just a flawed part of that bill to have police officers make up the hearing board. Also, the hearing board recommendation was reviewed by the chief of police. So even if we got past the fact that police are trying to regulate themselves and they came back and said that a police officer should be disciplined, the chief of police could basically toss that away and not discipline him. And of course, what do you have the hearing board for? What are they going through all of this for if the chief of police can toss it aside as if it didn't mean anything? So that was a major shortcoming of the Law Enforcement Officers Bill of Rights. Also, and one of the things that, let me just say this, when Delegate Jones assigned people to start considering this new law, one of the things they were doing was they were receiving information from members of the public. And one of the things that I sent to that committee that was considering the new law was that there should be no reason for you to expunge records of complaints filed against police officers. When you expunge records and remove it, they could leave that office, even though they've done terrible things, go to another police department, and they wouldn't even know they got a problem on their hand. So one of the recommendations I made to that committee when they were considering the new law is do not expunge records. Their job is so significant and they have such power and authority that people need to know who is on these police forces. So that was one of my recommendations. Under the Law Enforcement Officers Bill of Rights, they could do that. They could have 20 complaints, 30 complaints, 40 complaints, ask for it to be expunged, it would be removed, and we wouldn't know about it. And if you recall, this is one of the problems with Chauvin, the one who killed George Floyd. That was one of the problems with him. He had a lot of complaints, and basically nobody seemed to have known about that. And so that was one of the major problems with the Law Enforcement Officer Bill of Rights. Now, let me tell you what's good about the Maryland Police Accountability Act of 2021. There's certain things that are key key points about this. Number one, of course, it repealed the Law Enforcement Officer Bill of Rights, which was significant. But number two, civilian members must be on the Police Accountability Board. Civilian members must also be on the administrative charging committee, as well as the trial board. Now, this is a significant change. Insisting that civilian members be on this Police Accountability Board. The Police Accountability Board is the board that, so to speak, appoints a civilian to the administrative charging committee as well as the trial board. So it's very significant that we have a Police Accountability Board. Later on, when I get after Mr. Waddy speaks and I get back to the recommendations, I'm going to talk about how the county executives suggested they have 9 people on this Police Accountability Board. It's just a bad idea, and I'll explain that a little bit later. And I don't have to tell you, brothers and sisters, you can almost feel this, that the more folk you have on a Police Accountability Board during a crisis, the more likely it is that you're going to have some type of disagreement and difficulty and drag this process out. And that's one of the main things people have complained about when somebody gets killed. How long is it going to take the police officer to release those body cameras? It's just dragging the process out, and having a whole lot of people on the Police Accountability Board is just a bad idea, just fundamentally, because you want as few people as possible so the process can move on. Another thing is suspension without pay is permitted, pending an investigation. The charging committee and the trial board, that is very significant. Being able to suspend a person without pay puts teeth in the law. So when these police officers make these poor decisions, either because they're afraid or they're just incompetent, and somebody gets killed or crippled or something along those lines, suspending him without pay is pending the investigation getting started, and all of that is extremely significant because it makes these police officers think twice about doing this brainless stuff and killing people and all things of this nature. So that's a tremendous plus with the new law. Something else, there's a victim's right advocate. Brothers and sisters, let me tell you how important that is. Many times people do not even know what's going on. So they file a complaint with the police department under the Law Enforcement Officer Bill of Rights, and nobody's really talking to them. They basically getting information off the news. And so by having a new law requiring that there be a victim rights advocate, then they will inform the person whose relative got killed or they got hurt, something along those lines. They will keep them informed about the process, where it is, what the police officer is saying, and so they can be abreast of everything that's going on. Also, would give people some knowledge about, I need to make sure I get me an attorney with this thing, because this is really getting involved. Many folk have sat around, no attorneys by their side. The process is going on. They don't know where it is, what's going on. And next thing you know, you hear from the news that the police officer is not going to be disciplined. And so the new law requires it to be a victim's right advocate. Something else, no more expunging these records. The new laws put a stop to that. I'm real pleased that the committee accepted my recommendation to them in writing that stop expunging these records. The new law will put a stop to that, thank God. So they cannot hide when they do things that are unwise, or do things that are just inexcusable. So now if they leave a particular department where they got disciplined and go someplace else, the new department could look at their history and what they've been doing. Another thing too, applications for police must disclose all personnel and disciplinary records. I don't have to tell you, many times police officers will leave one department, go to another department, and they wouldn't really know what their history, what they did. And so the new law puts a stop to that. You must disclose full personnel and disciplinary records. And number 9, I want to share implicit bias training for all officers. Now, when we get to, after Mr. Waddy's speech, we get back to recommendations, I got to say something about that, because even though the law is detailed about implicit bias training and officers being tested, I don't see where they're required them to pass the test. That's absurd. And so one of the recommendations I'm going to be making later on is that we let them know they need to pass a test. Who cares if you got implicit training? You could have been sleeping there. We want to make sure you learn something and you can pass a test. And if you can't pass a test, then you have no business being on that police force. So that's another thing the new law requires, implicit bias training, but it didn't say anything about passing the test. And so I'll be talking about that later. And finally, tracking the use of force complaints each year. Now we're going to have a record, I should say a track record of what's going on in these police forces, tracking these use of force complaints. And so that will help us to know how effective or ineffective the police department is in implementing this new law. And so by tracking these complaints, it's almost unbelievable they weren't keeping up with this. But when you can expunge the records, you can realize how that becomes kind of impossible. But here, no longer that. We're no longer expunging the records so they can keep a track of all these use of force complaints, and that can be available to the public so we can see what type of police department we have and whether the whole police department, start with the chief police, need to have some implicit bias training. So it's going to give us a good look at what's going on. That's extremely important. And so that's kind of what I want to share to get started. And then I'll come back with recommendations after Mr. Waddy speaks. Thank you, Madam President.
Okay, that was amazing. Thank you, Reverend. And I really appreciated the energy that you brought to addressing that, as well as the insight that you have into the situation. So Monique, I don't know if you have the PowerPoint that I wanted to, if you could pull that up. So on January 6th, the inauspicious day, I guess, we had a meeting with the county executive's office regarding the implementation of police reform. I just wanted to say to everybody that's an NAACP member, please check out your newsletter, your December newsletter, because Judge Barber and the newsletter team gave a great outline, very informative outline of what the Police Accountability Board, what happened from the 2021 session with police reform. And so you all can review some of the other aspects of the police reform. And we do have, Delegate Bartlett and others that are on the call who can help us understand a little bit more, or give us insight, I guess, if we have, after we finish this conversation. So Monique, here we have, go to the next slide for me, please. So, I don't know. So this is what I just wanted to address the timeline that has gone on since from 2020 to 2022. I think we skip over that because I think that Reverend Jones laid out a little bit what we saw, what we heard from Leobor and to today. So the next thing I wanted to discuss a little bit was Leobor versus NPA. Reverend Jones did a great job going over some of the discrepancies between the two. The county executives proposed NPA structure where they see the ability for the county to have influence, and therefore our branch at the county level to have make recommendations and proposals for the county to implement on behalf of the NAACP and our membership. So we're talking about membership, the budget of the police accountability boards, staffing of police accountability boards, administrative charging committees, procedures related to them, and in terms of records retention and having an independent counsel, and a proposed timeline from these are items that we received from the county executive's office in that January 6th meeting. We're just trying to keep you all informed. And then advocacy next steps. We have a petition, and we will have a op-ed that's going to be published either tomorrow or Monday in the Capital Gazette regarding this, keeping the public informed and making them aware of civil rights advocacy groups' concerns. Okay, you can go to the next slide for me. So what changed? Leobor was repealed and replaced, and then we have some what occurred in the replacement: complaints about police conduct. They're not totally removed from police departments, but they are also, there's also the police accountability boards will also be able to receive complaints. We have community involvement in investigations, in police discipline and policy discussions. Standard use of force, the standard for the use of force is increased as well. So the standard for use of force, in addition to it being the use of force of complaints being tracked, now it has been increased and it's made uniform across the state. So the standard for use of force was not uniform across the state. It was county by county, department by department prior to this, and that affected much of the ability for people to be held accountable across jurisdictions. And then we do have the procedures for traffic stops that have changed. Again, all of this is in the newsletter. So if you have the opportunity, you can pull it up from your email now. Please go to the next slide. This is one of the items that we received from the county executive's office. This is a matrix from how they perceive the county's police accountability board to move forward. So every county in the state has to have a police accountability board now. We have there are certain, like in Prince George's County, they have already put out a request for people to submit names for the Police Accountability Board, and they're giving people 7 days to submit resumes from the time the request went out. And so, we actually have more influence on the process now here in our county, thankfully. And as you all can see, we have the Police Accountability Board receiving complaints from the public, forwarding the complaint to appropriate law enforcement agency. The law enforcement agency can also receive complaints from the public, and then the law enforcement agency will do the investigation. Upon completion of investigation, forward investigatory file to administrative charging committee. The administrative charging committee will review investigatory file and determine whether to charge a police officer. If an officer is charged, it determines allegations are unfounded or officer exonerated, and it must issue a written opinion with detailed findings, determinations, and recommendations. And then if the officer is charged, then it would issue the written opinion and recommends discipline according to the discipline matrix. Chief will offer discipline recommendations by the administrative charging committee or a higher level according to the matrix. And then if the officer does accept the discipline, then the discipline will be imposed. If the officer does not accept the discipline, the officer can be offered the access to the trial board. So the matter will be referred to the trial board for a hearing. Is a trial board hearing and decision. Officer does not appeal within 30 days, and trial board decision is final, and the officer appeals within 30 days. The circuit court appeal, it goes to circuit court. So that is what their perception of how the law moves police accountability forward from administrative issues. So, if there's a violation of a use of force and it's not acted upon, then Police Accountability Board receives a complaint from the public, then it can move, that's when this starts moving forward. So it might not even be use of force, maybe something related to police misconduct around, using impolite language, calling somebody the B word. There's different aspects of the complaint that can be issued, and then they will be reviewed by the Police Accountability Board or law enforcement agencies. Let's go to the next slide, please. Okay, so the state law requires these certain aspects of the Police Accountability Board, that it hold quarterly meetings with heads of law enforcement and otherwise work with law enforcement agencies and county government to improve matters of policing. The board shall appoint 2 civilian members to the administrative charging committee. The board shall appoint 1 civilian member who is not a member of the administrative charging committee to a trial board. The board can receive complaints of police misconduct filed by members of the police and must forward to the appropriate law enforcement agency within 3 days. Complaints shall include the name of the police officer, description of the facts, and contact information. of the complainant and the person filing a complaint for investigative follow-up, and the complaint needs not be notarized. That has been an issue in the past where it's been required that they be notarized. And then the outcomes and reporting, as you all can see there, they have to submit an annual report. Let's go to the next slide. So this was in terms of the negotiations between the different police departments and the county. So according to the law, the county board the counties can have their own board, right? The counties will have their own board. And then each police department may also be subject to a police accountability board. So that may be an issue for some jurisdictions like Prince George's County, but in Anne Arundel County, there's been an agreement that the Police Accountability Board will be serving these departments, the Anne Arundel County Police Department, the Anne Arundel County Sheriff's Department, Annapolis Police Department, Crofton Police Department, and the Anne Arundel County Community College Police Department. The local governing body in each county will be responsible for, this is the county council or commissioners in those types of jurisdictions that it will establish the membership of the Police Accountability Board, establish the budget and staff, appoint the chair for the Police Accountability Board who has relevant experience to the position, and establish the procedures for record keeping by a Police Accountability Board. The Police Accountability Board will be responsible for holding the meetings, as you all saw that in the last slide, so I'm not going to review that again. Let's go to the next one for me, please. All right, and so this was, if you look to the right, we have the proposed, that's the proposed county executive's proposal with 9 voting members. From the left, we have the state law requires that 1, an active police officer may not be a member of the Police Accountability Board. 2, it requires that the membership of the board reflect the racial, gender, and cultural diversity of the county. And then this was the suggestion that there be 9 voting members. 1 of the 9 members is the chair. 1 of the 9 members must be an Annapolis resident appointed upon recommendation by the mayor and city council, and all members must be county residents. That's the suggestion. There may be, other ideas on how Annapolis may appoint its own member to the board, as well as, the number of members. Let's go to the next. And then we also have this ex officio membership approach. So I also want to just preface all of this by saying that the reason why this is called the county executive's proposal is because the state law, according to the Anne Arundel County Charter, when a state mandate is issued, then the county executive is the one who proposes the implementation of the law to the county. So it's the county executive's responsibility according to our county charter. This is not necessarily like the county executive just taking control of this, but it's according to the law of our charter. And so that's why it's being termed this way. So at the council level, it will be introduced by the council president, Lisa Ravian, or the council chair, I'm sorry, at the request of the county executive's office. So that's like the process that will happen. So I'm not trying to give this a particular type of political side. I'm giving you the suggestions that are coming from the county executive's office. We have ex officio membership, which their possible approach is that they would include as non-voting ex officio members several individuals with expertise and knowledge that will be valuable to the board. These were the suggestions. We have our county equity, diversity, and inclusion director, and human relations officer designee, the chief of police designee, a sheriff's office designee, and these were some examples that they had in terms of the city of Annapolis police chief designee on an ex officio membership that would not be voting on any of these decisions. Then they discuss vacancies and removal. As you all can see here, vacancies filled in the same manner as original appointment for unexpired term, and members may be removed for cause like missing meetings, handling of confidential documents. Let's go to the next one. Not much longer. There's the budget and record keeping. Record keeping, state law requires local establishment. And then this is the process that they suggested, that the executive secretary shall keep records. The county administration shall establish a retention schedule in accordance with state law. Records shielded by state law for MPIA are kept confidential. And then we have state law requires establishment and possible approach for the budget and staff, for the board to have an executive secretary. And then the county executive shall propose a budget for the board that shall be included in annual budget appropriation ordinance adopted by the county council. And then we will have, it will require financial disclosure, conflict of interest, and ethics forms. Let's go to the next one. Here for the administrative charging committee, each county will have one administrative charging committee to serve countywide law enforcement agencies and law enforcement agencies within the county, and will be composed of the chair of the Police Accountability Board or their designee, 2 civilians appointed by the Police Accountability Board, and 2 civilians appointed by the CEO of the county. Statewide Administrative Charging Committee will also be created. 3 civilians appointed by the governor, 1 civilian appointed by the President of the Senate, and 1 by the Speaker of the House. Administrative and Charging Committee, you can see its responsibilities, and we've discussed them already. And you can go to the next one. So here's the timeline that we have. It's doing stakeholder engagement and outreach, introduction of legislation in February, public hearings, council meetings in March, submission of names to council for approval, April, May, because all of this has to be done by July 1st. And then we would have the first accountability board meeting, April, May, training, hiring staff, developing internal processes in June, and July 1, state mandated process goes into effect. And so then we have next steps. We do have, the 2020. So you can go back to the 2021. So in 2020, we did have, after George Floyd was murdered, we had a, dog's got to go out. So hold on a second. Well, no problems.
While Mr. Waddy has stepped away, I would like to recognize Delegate Rogers and Delegate Bartlett, who is with us, Scott Poirier, and Council Lady Sarah Lacey, and Judge Sidney Butcher are with us today. And I see Mr. Waddy is back.
Thank you. Sorry about that. So we had civil rights advocates. So after George Floyd was murdered, and we had the thousands of protesters across the county came out, risking their lives during the quarantine to address these concerns. We responded to by engaging with the we had the body cameras were added by the county council and the county executive into the budget. So now the body cameras was a response to that. And then we've all seen that the body cameras aren't necessary. Body cameras are basically, something from the 90s, really, that hasn't changed much in terms of police officers feeling able to kill unjustly. So we also were taught this community oversight of the police was also addressed within the civilian review board, because we had Baltimore City had a civilian review board, and Prince George's County already had a civilian review board for police actions. And so that's what our discussion was. We did engage with meetings with the county executive's office on that. And this was prior to the 2021 session. So all of these, we had a whole series of discussions amongst the civil rights groups around this. And these were some of the recommendations that the membership suggested prior to the 2021 session. And you all can see them here. To be effective, it must have independent outside counsel and not representation by county attorney, and must have qualified data and policy analysts. So, and we also suggested that it be at least 1% of the current budget, and receive complaints, review police investigations into internal affairs complaints, and have subpoena power. So those were some of the suggestions that came out of 2020 that we feel as though it will be useful for 2022 as well. Go to the next slide. And so here, our next step, we have a petition. I can share that with you all in the chat, and then we have an op-ed, and once you all see that, once it comes out, we'll share it with everyone through our email, and you all can share that with your constituents or with your friends and family, and also to write the county executive and the county council requesting that they have a strong and independent police accountability board. Thank you. So, Reverend Jones, I want to toss it back to you.
Thank you, Mr. Waddy. Madam President, I have some recommendations for the NAACP, and I will reduce them to writing and forward them to Sister Monique. And so at this time, Madam President, I would like to go forward my recommendations, if that's okay with you.
Yes, you can move forward with the recommendations thus far by the committee chairs, and following that, then we will have questions from the membership if they have any other recommendations to submit. And Secretary Brown will be calling on folks according to the raised hands that come up. So please continue, Reverend Jones.
Thank you, Madam President. And Secretary Brown, I will forward this to you in writing. Here's some of the recommendations, Madam President. Number one, the county executive recommended 9 people for the Police Accountability Board. Madam President, let me tell you why that's a bad idea. Whenever you have a crisis, usually it will be extremely difficult to get 9 people to agree on anything. And so the fewer numbers that we have on a Police Accountability Board, the greater the risk, the greater it is that we can get some type of an agreement and movement on the matter. The Police Accountability Board can move this process along pretty quickly. The more people on that board, the more likely is you're going to have disagreement, the more of a risk of there being in the past. And so 9 people on the Police Accountability Board, I believe, is not a good idea. I would recommend 3 people, no more than 5. That's number one. Number two, we must ensure that the Police Accountability Board staff have an experienced attorney on that board. And what I mean, preferably a civil rights attorney, but not necessarily a civil rights attorney, but an experienced attorney on that board. Many times, Your Honor, excuse me, Madam President, an experienced attorney, especially in civil rights, can give some invaluable guidance to people who may not be involved with civil rights like that. I think that leaving an attorney off with some rich experience, especially in civil rights, is a blueprint for disaster. Because if folk are not familiar with the magnitude of this fight, the evil that you're involved with when you're dealing with these police killings and things, and this cover up of this kind of stuff, if you don't appreciate the magnitude of that, you perhaps will go in the wrong direction. But anybody who's been practicing law, especially in civil rights, for over 30 years, you're not going to fool Reverend Jones or somebody else like Reverend Jones. We know what's going on. And I believe it'll be an invaluable asset for the Police Accountability Board if they have on that board an experienced attorney, preferably experienced with civil rights. Number 3, the implicit bias test, as I said earlier, it must be passed. The fact that the law says they're to take implicit bias training, who cares about that? Did they pass the test? If you don't pass the test, you still don't get it. And so there must be some minimum grade in which they will be deemed to have passed the test. And I believe we need to recommend fine implicit bias training, fine, you learn about what you shouldn't be doing, but we won't know that you got it. You won't sit there sleeping or daydreaming, pass the test. Number 4, the 30-day extension must follow pending any investigation. When a police officer has been accused of killing somebody or hurting somebody or violating the police rules and regulations, there must be an immediate suspension. Many times, Madam President, when a suspension is part of the investigation, it puts teeth behind the law, and it makes these police officers think 3 times before they act in a manner that deems, I believe it would deem that somebody's either afraid or incompetent shooting somebody unarmed. Number 5, this multiple use of force incidents should also require implicit bias training. If the police department has multiple use of force incidents, clearly they're not getting it on that police department. Everybody, from the chief of police all the way down to the person they hired yesterday, need to have implicit bias training and pass the test if you have a multiple use of force incidents and complaints. Number 6, prohibit non-voting members. This ex officio type stuff they talk about putting on the board, that's a bad, Madam President, that's a bad idea. Let me tell you why it's a bad idea. When you put people on the police accountability board, like some former officers and people who are employed with the government, they have a tendency of influencing people, and we don't. It's just to put a retired police officer on that police accountability board, I believe is just not a good idea because of the history with these police departments. Rarely did police departments sitting on these hearing and trial boards, rarely do they recommend the police be disciplined and terminated. And that hasn't happened a lot of times. And so that history kind of lets us know this law is designed to bring it into that kind of stuff. So why are you still trying to push them on the board, either as a non-voting member and certainly as a voting member? They should not be on the police accountability board, in my opinion. And I will share the one exception I can think of for that. But generally, they should not be on that board. I think this is number 7 now. The only exception I can think of, Madam President and brothers and sisters, of putting a retired police officer on the police accountability board is this. If the police officer is from our community and has a history, a public history of advocating for police reform, I'm not talking about since George Floyd, I'm talking about Freddie Gray or prior to that, a public history of advocating for police reform. If a retired police officer remains silent and never advocated for police reform, what in the world makes us think that he's gonna be the type of help to the police accountability board at a time of crisis when serious decisions need to be made? I don't believe that that person would be if they have no public history of advocating for police reform. Another thing, we might as well recognize this. When police officers are under investigation for killing somebody or hurting somebody or something along those lines or violating some rule regulation, I can tell you now, so I don't want anybody to be surprised in the future, they're going to the trial board, because the trial board passed the police accountability, passed the administrative charging committee, they're heading to the trial board, because on the trial board, you only have 1 civilian that could be appointed. The other 2 people would be a retired judge and an active police officer. So I can tell you they're headed to the trial board. Therefore, we need to think about that. And we need to be sure that the person put on that trial board, we hope the police accountability board will understand this. The person put on the trial board must be somebody who is knowledgeable, preferably about the law, who is fearless, and who is definitive about their position. If you get somebody on that trial board, a civilian on that trial board, who is afraid or who's scared or who won't speak up or who's not knowledgeable about the law to some extent, you can pretty much be sure that person will be persuaded by this retired judge and active police officer. You're going to have somebody who can see clearly what's going on, what has happened, and not be intimidated whatsoever. And finally, Madam President, I'm going to reduce all this to writing, as I said. As far as the community is concerned, I think the NAACP needs to get to the community and let them know when there's some type of complaint that you want to file, the police accountability board should be the place you go to first, not the law enforcement agency to send them a copy. But the police accountability board must be the first people you file your complaint with, because the police accountability board is put in place to deal with this kind of stuff. Going to the law enforcement agency, that's been done already. Now, I know we got new law to kind of give them some directions and all, but we've already gone down that road. We are trying to go in a direction that will not undermine this law. We're trying to make the law effective in the implementation. This is the reason why I'm saying 9 people on the police accountability board is just too many. We don't want anything that directly or indirectly, explicitly or implicitly undermine the law. We have a serious problem with police departments in this country, and this law is designed to bring a stop to that kind of stuff. So we can't be talking about, well, put the police officer on the police accountability. No, that's the problem. They failed at regulating themselves. They failed at making sure they made these police officers accountable. So don't try to squeeze them on the police accountability board now. They're going to be forced on it with the trial board. That's bad enough, but not on the police accountability board. So these are the recommendations that I have, Madam President and brothers and sisters. Thank you very much for the time.
You have heard from our political action chair and also from our criminal justice chair. And they both gave an excellent presentation.